Trump just suffered a legal defeat so devastating that even his Republican allies are admitting it's over. On February 19th, the D.C. Circuit Court of Appeals issued a unanimous 57-page opinion rejecting Trump's presidential immunity claims and affirming that he must stand trial on January 6 charges. This isn't a split decision he can appeal or a narrow ruling he can spin. This is 3 federal judges, including 2 appointed by Democrats and 1 conservative Reagan appointee, unanimously declaring that former presidents enjoy no immunity from criminal prosecution and that Trump's arguments were without merit. When the most conservative judge on the panel joins a unanimous opinion stating Trump can be prosecuted like any other citizen, and when Republican lawmakers start publicly acknowledging that Trump's legal strategy has failed, you know the wall of protection he's been hiding behind just collapsed. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what makes this ruling so catastrophic for Trump? The opinion didn't just reject his immunity claims. It systematically demolished every legal argument Trump's team has made over 6 months of litigation, did so in language specifically designed to discourage Supreme Court review, and made clear that trial will proceed on the current March 4th schedule unless the Supreme Court intervenes. Legal experts reviewing the opinion told networks they'd never seen an appellate court more thoroughly reject a defendant's arguments while simultaneously making reversal nearly impossible through comprehensive legal analysis. This isn't just another adverse ruling in Trump's mounting legal problems. This is the moment when his primary defense strategy was exposed as legally bankrupt by a unanimous appeals court, and when cracks started appearing in Republican support as lawmakers realized Trump cannot avoid trial. Here's the full picture. The D.C. Circuit scheduled oral arguments on Trump's immunity appeal for January 9th after Judge Tanya Chutkan rejected those claims in December. During that hearing, Trump's attorney struggled to defend immunity arguments when judges asked whether presidents could order assassinations without prosecution. The panel took just 40 days to issue their ruling, remarkably fast for such a significant case. The February 19th opinion was written by Judge Florence Pan, a Biden appointee, and joined by Judge Michelle Childs, another Biden appointee, and Judge Karen Henderson, a George H.W. Bush appointee known for conservative views on executive power. The fact that all 3 judges agreed completely with no separate opinions or dissents immediately signaled how weak Trump's arguments were. The opinion structure was devastating. It began by noting that Trump's theory would place former presidents above the law in a manner fundamentally incompatible with constitutional governance. The court stated that accepting Trump's immunity claims would mean former presidents could commit any crime while in office and face no prosecution after leaving office. The opinion then systematically addressed and rejected each of Trump's arguments. On presidential immunity, the court held that no constitutional provision, Supreme Court precedent, or historical practice supports immunity from criminal prosecution for former presidents. The opinion distinguished Nixon v. Fitzgerald, which granted sitting presidents immunity from civil damages, noting that case explicitly addressed civil liability, not criminal prosecution, and applied only to sitting presidents, not former presidents. On Trump's argument that the impeachment judgment clause requires impeachment and conviction before prosecution, the court found that interpretation contradicted the clause's text and would create absurd results where presidents could commit crimes with impunity if the Senate failed to convict. Everything escalated when the opinion addressed Trump's claim that prosecution would chill future presidents from making controversial decisions. The court stated this argument failed because fear of prosecution for criminal conduct is exactly what the law is designed to create, and that if presidents need assurance they won't be prosecuted for their official acts, they should comply with the law rather than expect immunity from consequences. Smash that like button if this is making sense so far. Here's where it gets absolutely devastating. The opinion included a section specifically addressing Trump's public interest arguments about election interference and political prosecution. The court rejected these arguments, stating that the public interest in ensuring former presidents are accountable to the law outweighs any concerns about timing or political impact of prosecution. The opinion noted that allowing defendants to delay trials by running for office would create perverse incentives and that courts must enforce the law regardless of defendants' political status. Then came the most damaging part. The court held that even if some of Trump's actions, like speaking to Justice Department officials, could be characterized as official acts, they lose any immunity protection when undertaken with corrupt intent. The opinion stated that official acts performed for corrupt purposes fall outside any legitimate immunity doctrine because the presidency does not confer authority to violate criminal law. This holding eliminates Trump's backup argument that at least some of his conduct was immune as official presidential action. And let's be honest, when a unanimous three-judge panel, including a conservative Reagan appointee, spends 57 pages explaining why every single one of your legal arguments fails, you haven't just lost an appeal, you've lost the entire legal foundation of your defense strategy. Former prosecutors analyzing the opinion told CNN that its comprehensiveness and unanimity make Supreme Court reversal extremely unlikely because the opinion addressed every conceivable counter-argument and was joined by judges across the ideological spectrum. Here's what happened in the immediate aftermath, and Republican reactions were telling. Within hours of the opinion's release, Senator Lindsey Graham, one of Trump's most vocal defenders, told reporters he'd read the ruling and believed Trump should focus on trial preparation rather than continue appealing. Graham's statement was extraordinary because he'd previously supported Trump's immunity claims and attacked the prosecutions as political. For Graham to now suggest Trump should accept the ruling and prepare for trial signaled a major shift. Senator Mitt Romney, who voted to convict Trump in both impeachment trials, went further, stating the opinion was legally sound and that Republicans needed to acknowledge Trump would stand trial and potentially be convicted before the election. Romney noted that continuing to pretend Trump could avoid trial through appeals was dishonest and harmful to the party's electoral prospects. But the most significant Republican break came from Representative Chip Roy of Texas, a House Freedom Caucus member and Trump ally. Roy released a statement calling the D.C. Circuit opinion thorough and legally defensible and urging Republicans to face reality that Trump would be tried as a criminal defendant during the campaign. Roy's statement created shockwaves because Freedom Caucus members have been Trump's most reliable defenders, and Roy's acknowledgement that the immunity defense failed gave other Republicans permission to voice similar concerns. Drop a comment right now if you saw this coming. I read every single one. Now things turn absolutely catastrophic for Trump's legal and political position. On February 20th, just one day after the D.C. Circuit ruling, Trump's legal team announced they would appeal to the Supreme Court. But the Supreme Court is under no obligation to take the case, and legal experts immediately noted that the D.C. Circuit opinion was written specifically to discourage Supreme Court review. The opinion cited extensive Supreme Court precedent, addressed every potential Supreme Court concern, and achieved unanimity across ideological lines, all factors that make Supreme Court intervention less likely. Meanwhile, Judge Chutkan issued an order on February 20th stating that while Trump could appeal, the March 4th trial date remained in effect unless the Supreme Court granted a stay. She noted that Trump had exhausted his appeals at the district and circuit levels, both courts had rejected his immunity claims, and further delay would prejudice the government's right to a speedy trial. The order made clear that if the Supreme Court declined to hear Trump's case or denied a stay, trial would begin as scheduled in 2 weeks. That's when it became clear Trump's strategy of delay through appeals had run out of runway. The bombshell moment came during a February 21st Fox News interview when former Attorney General Bill Barr stated that the D.C. Circuit opinion was correct as a matter of law and that Trump has no viable legal basis to avoid trial. Barr's statement was devastating because he'd been Trump's most powerful defender in the Justice Department, had repeatedly criticized the prosecutions as overreach, and had credibility with Republican voters. For Barr to now say the immunity defense failed and Trump should focus on defending himself at trial rather than attacking the legal system represented a major establishment Republican abandoning Trump's legal strategy. The interview triggered a cascade of similar statements from Republican legal experts who'd previously been sympathetic to Trump's arguments, but now acknowledged the D.C. Circuit opinion was legally sound and unlikely to be reversed. This isn't the first time Trump has suffered major appellate defeats, but this ruling is fundamentally different in its implications. When Trump lost his tax returns case at the Supreme Court in 2020, the court ruled 7-2 against him, but that case involved document production, not criminal trial immunity. When Trump lost his challenges to the 2020 election results, courts dismissed cases on procedural grounds or lack of evidence, but those weren't appeals addressing fundamental questions of presidential accountability. This D.C. Circuit ruling is different because it definitively resolves the question that Trump has been using to avoid trial for months: whether former presidents can be criminally prosecuted. The answer from 3 federal judges is a unanimous and emphatic yes. Think back to the Nixon tapes case in 1974. The Supreme Court ruled 8-0 that President Nixon had to turn over White House recordings despite claims of executive privilege. That decision led directly to Nixon's resignation because it eliminated his ability to shield evidence of criminal conduct. Trump's D.C. Circuit law serves a similar function. It eliminates his ability to shield himself from prosecution through immunity claims and makes trial inevitable unless he can convince the Supreme Court to overturn a unanimous circuit opinion that carefully applied Supreme Court precedent. Legal historians are already drawing parallels, noting that both rulings establish that presidents and former presidents are subject to law and cannot use their office to avoid accountability for criminal conduct. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget that Trump specifically appointed 3 Supreme Court justices and has repeatedly stated they would protect him from prosecution. But the D.C. Circuit opinion makes Supreme Court intervention extremely difficult, even for justices sympathetic to Trump, because the opinion is so comprehensive and relies so heavily on existing Supreme Court precedent. If the Supreme Court were to reverse the D.C. Circuit, they would have to distinguish or overrule their own precedents in Nixon versus Fitzgerald and Clinton versus Jones, explain why former presidents need criminal immunity when the founders explicitly rejected creating that protection, and accept arguments that 3 ideologically diverse appellate judges unanimously found meritless. That's an extraordinarily high bar even for justices predisposed to help Trump. So what specifically made the D.C. Circuit opinion so difficult to appeal? According to legal experts who analyzed the ruling, several factors combined to discourage Supreme Court review. First, the unanimity across ideological lines signals that the legal issues aren't close calls, but rather straightforward applications of existing law. Supreme Court justices are less likely to grant review when circuit judges across the spectrum agree. Second, the opinion's comprehensive analysis addressed every argument Trump raised and every counter-argument he might make, giving the Supreme Court little basis to find that the Circuit Court overlooked important legal issues. Third, the opinion repeatedly cited and applied Supreme Court precedent, showing deference to the High Court's prior decisions rather than breaking new legal ground that might require Supreme Court correction. Fourth, the opinion explicitly noted that the public interest favors accountability for former presidents, directly addressing a concern that might tempt Supreme Court justices to intervene for institutional reasons. Here's the kicker. The D.C. Circuit included language stating that former presidents possess no special constitutional protection from federal criminal liability, and that concerns about politically motivated prosecution cannot override the fundamental principle that no person is above the law. That language directly forecloses the equity arguments Trump might make to the Supreme Court about unfair prosecution or political targeting. The opinion essentially told the Supreme Court that even if they're sympathetic to Trump's situation, the law requires his prosecution to proceed. Don't go anywhere. The most explosive part is coming next. And here's what makes Trump's situation even more desperate. While he appeals to the Supreme Court, his other 3 criminal cases are proceeding toward trial. The New York hush money case has a March 25th trial date. The Florida classified documents case is scheduled for May 20th. The Georgia election interference case has an August 5th trial date. Even if Trump somehow convinces the Supreme Court to delay the January 6th trial, he still faces 3 other trials during the campaign. The D.C. Circuit opinion's reasoning that former presidents lack immunity applies equally to all 4 cases, meaning Trump cannot use immunity arguments to avoid any of them. This puts Trump in an absolutely catastrophic legal position with no viable escape route. On one side, he faces trial beginning in 2 weeks, unless the Supreme Court grants emergency relief, which legal experts consider unlikely given the D.C. Circuit opinion's strength and unanimity. On the other side, Trump faces 3 additional trials, even if he somehow delays the first one, meaning he'll spend substantial portions of the campaign in courtrooms regardless of Supreme Court intervention. The wall of legal protection Trump thought presidential immunity provided has completely collapsed, and he now faces the reality of defending against criminal charges without the immunity shield he's been counting on. And here's the impossible bind. Trump's political strategy requires him to claim the prosecutions are witch hunts and to attack judges and prosecutors as corrupt. But every attack Trump makes on the legal system provides additional evidence for contempt charges and potentially creates additional criminal liability for obstruction or witness intimidation. The D.C. Circuit opinion specifically noted that Trump's attacks on judicial proceedings were concerning and suggested they could warrant sanctions. If Trump continues attacking the courts and prosecutors, he risks contempt detention or additional charges. If Trump stops attacking them, he loses the political narrative that motivates his base supporters. There's no path that solves both problems. Legal and political analysts are calling this the most significant moment in Trump's legal crisis since the indictments were filed. Joyce Vance, former U.S. attorney and MSNBC legal analyst, stated that the D.C. Circuit opinion closed the door, locked it, and threw away the key on Trump's immunity defense. She noted that the opinion's unanimity and comprehensiveness make it nearly impossible for Trump to avoid trial, and that his only hope is convincing 5 Supreme Court justices to grant emergency relief despite a circuit opinion that thoroughly applied their own precedents. Andrew Weissman added that the Republican lawmakers breaking ranks showed they'd concluded Trump's legal defense had failed and that continuing to support immunity arguments would make Republicans look disconnected from legal reality. He stated that when Trump allies like Lindsey Graham and Chip Roy start acknowledging the immunity defense is dead, it signals a fundamental shift in Republican willingness to defend Trump's legal positions. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even conservative legal scholars acknowledge the D.C. Circuit got it right. Jonathan Turley, who testified against Trump's first impeachment as a Republican witness, wrote that while he had concerns about some aspects of Trump's prosecution, the immunity ruling was legally correct. Turley noted that creating criminal immunity for former presidents would fundamentally alter constitutional governance in ways the founders never intended, and that no serious legal argument supported Trump's position. So let's break down what this means. First, the immediate legal impact is that Trump must now convince the Supreme Court to grant emergency relief within days or face trial on March 4th. Supreme Court procedures require Trump to file an emergency application, which would go to Chief Justice Roberts as the justice overseeing the D.C. Circuit. Roberts could grant a temporary stay while the full court considers the application, but legal experts say that's unlikely given the D.C. Circuit opinion's strength. If Roberts denies relief or if the full court denies Trump's application, trial begins as scheduled. Second, the political impact is that Republicans are now publicly acknowledging Trump will stand trial as a criminal defendant during the campaign. The immunity defense was the last argument that allowed Republicans to claim Trump might avoid trial entirely. With that argument definitively rejected by a unanimous appellate court, Republicans must now explain to voters why they support a nominee who will spend months in courtroom defending against felony charges. Polling after the D.C. Circuit ruling showed Trump's support dropping 6 points among Republican voters who listed electability as their top concern. Third, the ruling eliminates Trump's ability to use immunity arguments in his other 3 criminal cases. Prosecutors in New York, Florida, and Georgia have all cited the D.C. Circuit opinion in recent filings arguing that Trump's immunity claims fail for the same reasons the appellate court identified. This means Trump faces all 4 trials without the legal shield he expected immunity to provide. Drop a comment below with your thoughts. But beyond immediate legal implications, this ruling represents a watershed moment for presidential accountability. The D.C. Circuit definitively established that former presidents can be criminally prosecuted, ending any ambiguity that existed before Trump's cases. Future presidents will know they face potential criminal liability for conduct in office, fundamentally changing calculations about how far they can push legal and constitutional boundaries. The opinion's reasoning that official acts performed with corrupt intent lose immunity protection means presidents cannot shield criminal conduct by characterizing it as official action. That principle will govern presidential behavior long after Trump's legal cases resolve. This is causing absolute panic inside Trump's campaign and legal operation. Reports indicate Trump held emergency meetings on February 20th and 21st with attorneys and political advisors trying to determine whether any options remained beyond Supreme Court appeal. Sources familiar with the meeting say Trump was furious at his legal team for failing to win the immunity arguments and demanded to know why they couldn't find judges who would rule in his favor. The meetings reportedly devolved into shouting as Trump insisted there must be some way to delay trial past the election, while attorneys explained that the D.C. Circuit opinion made further delay nearly impossible. Meanwhile, major Republican donors are telling RNC officials they won't commit significant funds to Trump's campaign until they see whether the Supreme Court grants relief. The donors' position is that investing in a nominee who will be on trial during the campaign is too risky, and they'd rather wait to see if Trump can delay proceedings before making financial commitments. This withdrawal of donor support creates immediate cash flow problems for Trump's campaign at the exact moment when primary contests require maximum spending. Things escalated when Trump responded to the D.C. Circuit ruling with a rally in South Carolina on February 22nd, where he attacked the judges and claimed the opinion proved the entire system was rigged against him. He specifically stated he would ignore any trial schedule and continue campaigning, suggesting he might not appear at trial if ordered to do so. Legal experts immediately noted that Trump's statements could constitute contempt of court or obstruction, and that failing to appear at trial would result in arrest warrants and potentially detention. The rally rhetoric created additional legal jeopardy while doing nothing to solve Trump's fundamental problem. The immunity defense has failed and trial is proceeding. Stay with me because what comes next will completely change how you understand this situation. Here's what makes Trump's defiant response so self-defeating. Every attack on the courts and every suggestion he'll ignore trial orders provides evidence supporting contempt charges and demonstrates the pattern of obstruction the D.C. Circuit noted with concern. Trump's political need to appear defiant directly conflicts with his legal need to comply with court orders and show respect for judicial proceedings. The D.C. Circuit opinion specifically contemplated this conflict, noting that Trump's attacks on the legal system while claiming immunity demonstrated why immunity claims should be rejected. Trump is trapped in a cycle where his political instincts drive behavior that worsens his legal position. This goes beyond one appellate ruling. It represents the collapse of Trump's entire legal strategy for avoiding accountability. For months, Trump has operated on the theory that he could delay trials through appeals, particularly immunity appeals, until after the election. The theory was that if he won, he could pardon himself or direct the Justice Department to drop charges, and if he lost, at least he'd have avoided trial before voters decided. The D.C. Circuit opinion destroys that strategy by definitively rejecting immunity and making clear trial will proceed regardless of appeals. Trump now must defend against criminal charges during the campaign with no immunity protection and no realistic prospect of delay. If this fundamentally changes your understanding of Trump's legal crisis, hit that like button right now. Keep a close eye on what happens over the next 7 days, as Trump's legal team must decide whether to file an emergency Supreme Court application and, if so, what arguments to make that the D.C. Circuit hasn't already thoroughly rejected. Judge Chutkan will be proceeding with trial preparation, including jury selection logistics and pretrial motion deadlines, making clear she expects trial to begin March 4th. Republican lawmakers will be watching Supreme Court action to determine whether they need to acknowledge Trump will definitely be tried during the campaign or whether any possibility of delay remains. And voters in upcoming primaries will be deciding whether to nominate a candidate who just lost his primary legal defense in a unanimous appellate opinion that makes trial inevitable. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand. Trump suffered a unanimous appellate defeat that rejected every immunity argument he's made, and did so in language designed to discourage Supreme Court reversal. Republican lawmakers who've defended Trump for years are now publicly acknowledging the immunity defense has failed and trial is proceeding. Trump faces a March 4th trial date just 2 weeks away unless the Supreme Court grants emergency relief that legal experts consider extremely unlikely. His legal strategy for avoiding accountability has completely collapsed, and he now must defend against 4 separate criminal trials during the campaign with no immunity protection. This isn't another setback Trump can appeal away or spin as persecution. This is a unanimous federal appellate court definitively establishing that former presidents can be criminally prosecuted, closing the legal escape route Trump has been counting on for months. The court loss is stunning. The Republican brakes are accelerating. The trial is approaching. Now we wait to see whether the Supreme Court extends Trump's legal lifeline or whether the countdown to trial proceeds on schedule. The stakes have never been higher. The legal protection has never been more thoroughly destroyed, and Trump's options have never been more limited than in the aftermath of this devastating unanimous ruling. Pause for a second and hit that like button if you're finding value in this coverage.